First of all, I want to say good afternoon to you all. Thank you all for coming out. Want to acknowledge the DA and Fulton County Sheriff. We're here today to speak on the arrest of Jeffrey Williams that in collaboration with Fulton County DA's office and the Fulton County Sheriff on yesterday. This collaboration is representative of the partnership with the Atlanta Police Department and the DA's office on our aggressiveness and going after gang members. The mayor as well as the DA gave a interview on last week expressing their concerns about what we were seeing in our city and how we would go after any offender. And at the direction of the DA taking the lead on us yesterday, making sure that we were able to get one of our top offenders off of the street. In partnership with them, utilizing our tactical teams, we were able to go out to the individual's location and arrest him without any significant consequences to him or any other parties at the house. And so with that, I'll turn it over to the DA.
Thank you, Chief Bryant. Today I'm joined by the Atlanta Police Chief, Chief Rodney Bryant, as well as my sheriff and our sheriff, Sheriff Patrick Labatt. We are here today about a grand jury indictment that was returned that included not just Jeffrey Williams, which is of some notoriety and media attention, but about 28 defendants that operated within our community between the time period of 2012 and 2022. It is our allegation that they operated as a criminal street gang and commenced to do havoc in our community. That havoc includes crimes of violence, crimes of thefts, crimes involving drugs. I've made no secret about it, nor any apology, that as the District Attorney of Fulton County, my #1 focus is targeting gangs. And there's a reason for that. They are committing conservatively 75 to 80% of all of the violent crime that we are seeing within our community. And so they have to be rooted out of our community. I said just a week or two ago, it does not matter what your notoriety is, what your fame is. If you come to Fulton County, Georgia, and you commit crimes, and certainly if those crimes are in furtherance of a street gang, that you are going to become a target and a focus of this district attorney's office, and we are going to prosecute you to the fullest extent of the law. I agree with Chief Bryant. What you see yesterday and what you will see in the upcoming months and years is the result of a lot of hard work by both the Atlanta Police Department and this office. We are proud to bring forth this indictment and hopefully to bring justice to a lot of the community who was victimized through the course you see in this indictment. But more importantly, the most important thing that we are here to do is to keep this community safe, and we believe removing these 28 defendants will keep Fulton County safer. Yes, sir.
The indictment's got Young Thug and a bunch of other rappers. There was one name I was actually expecting to see there that I didn't, and that's Jack Harlow. Can you speak to that?
What I'll tell you is that as large as this indictment is, I told my team that let's not be sexy, now let's not overreach, let's be conservative in our approach, which is always the approach that I take. And in taking that approach, 28 defendants were indicted, and they were indicted for the crimes that I believe were appropriate for this RICO indictment. And so I won't speak to any person that is not named.
These are serious, significant charges. I would imagine you're going to see some pretty serious sentencing here. I know it's early, but can you talk a little bit about the type of sentences they might be facing?
Well, we'll ask on the different charges for the maximum penalties, and there's obviously many people that are looking at life under this indictment. You're absolutely right. These are serious times. They're serious allegations, and it is my opinion that violence in our community deserves maximum penalties.
In a recent interview, you said in the coming weeks and months to expect indictments, RICO charges, gang charges. We see that with fear, but this is only focused on the YSL gang. At that time, you used plural indictments. Should we expect more indictments against singular gangs in the coming weeks and months? Is that what you were meaning with that quote?
Yeah, and if you're already aware, we dropped an indictment not that long ago against YFN. It is certainly a tool that I believe in, which is using RICO. I believe, the reason that I believe in it as a tool is it allows juries and the communities to see the complete picture of a crime so they can truly be educated and have facts to weigh when they're making decisions. And so if you're asking, should you expect to see other RICO indictments against other street gang organizations? Absolutely.
And two questions specific to YSL, with the 20-some people arrested here or named. How big is this gang? Is that a good portion of the gang you're operating in Atlanta, and how long were you investigating them?
If you look at the indictment, the crimes that are alleged within it go all the way back from 2012 to 2022. I wouldn't say that it contains every act of crime that YSL committed. It is a significant gang that operates here in Atlanta, Georgia, and not every member became a defendant within this indictment, but certainly a significant amount did, and certainly some of the leadership, which is what's most important. We're not going to just target the children that are running out at the direction of leaders and not target leaders.
Madam DA, how much?
Go ahead, Michael.
Sure. How much did social media, music play a role in bringing this indictment?
Social media is a wonderful tool for prosecutors in every indictment we bring nowadays.
And let's talk about, obviously, YSL. There are the territories at Cleveland Avenue. It's no secret. We've seen a ton of violence. Innocent bystanders get hit. So you guys believe that by getting them off the streets, that people in that neighborhood who are living in fear can actually have some peace now?
I believe that people in that neighborhood and at every corner of Fulton County deserve to be safe, even if it is financially lower, socially, economically. You know, I don't think that part of the community should be left behind. Me and the mayor and the police chief have talked about the fact that Cleveland in our community is referred to as Bleveland, that it is somewhere where just violence occurs, where they're marking up territory, it's blood territory. It's horrible. And you're absolutely right, that community deserves to be safe, and we are hoping that this helps to keep them safe.
Willis, we talk about safety, we know these gang members are going to be housed or brought in at the same time. How are you and Sheriff Labatt working to keep them away from each other in the jail, especially with Wyatt and Lucci being targeted, as that came out recently?
Well, I won't step outside of my lane. I am the district attorney of Fulton County. I am not the sheriff. I have great confidence in the sheriff. He knew that this was coming as a law enforcement partner, and I believe that he is well prepared, but you'd have to speak to him to make sure that everyone within his facility is safe.
This indictment names a few, it's not just social media posts, but songs that have been released by Young Thug and others, where it goes through the lyrics, evidence supporting the RICO conspiracy. And I'd like you to speak to the First Amendment issues that obviously raises.
This issue's been ruled on by the courts. I knew that question was coming. I believe in the First Amendment. It's one of our most precious rights. However, the First Amendment does not protect people from prosecutors using it as evidence if it is such. In this case, we put it as overt and predicate acts within the RICO count because we believe that's exactly what it is.
Let's allow Sheriff Labatt to answer.
There's nothing more powerful than the odor of mendacity.
And welcome back inside the law, everyone. I'm your host, Philip Holloway. What you've just watched was, I felt compelled to show you where this all started, because where we are now, we're at a place where that district attorney, who is so proud of the First Amendment, she says, wants to silence the lawyers from coming on social media or anywhere else and speaking on behalf of their clients outside the courtroom. So there's a lot going on here, and we're going to bring in my friend Doug Weinstein, who is he's one of the architects of the removal, recusal of Judge Glanville, and one of the key players involved in the various motions that are flying around and that we've been discussing here inside the law in recent days. but the thing about that press conference, okay, Doug has cited it. Brian Steele has cited it in their response to the state's motion for a gag order. And their point is say, look, if Fani Willis can come out here on the courthouse steps or wherever and assemble all the media, and she's got all of the local law enforcement with her standing there on stage and, you know, making this big production and talking about how evil their clients are. Basically, look, announcing an indictment is one thing, but she did a lot more than that. Her purpose was not simply to announce an indictment. Really, all she had to do if she wanted to announce the indictment is do a press release, or at the very most come out and make a statement. Look, we've indicted these individuals. Here's the charges. We'll even give you a copy of it. I'm not going to answer any questions because this is a case that is, you know, actively being prosecuted, and it wouldn't be proper for me to go into it anymore. We will do our talking from here on out in the courtroom. And that's all she would have had to do. That's it. But instead, she went a lot further and she started, you know, answering a lot of these questions. And I don't begrudge any prosecutor, by the way, for fighting crime. I mean, nobody here is pro-crime. That's not what this is about. This is about, you know, the fairness or the lack thereof of a criminal case or any criminal case. And it's, you know, it's how prosecutors go about prosecuting these cases. They are the ones that drive this train. It's not the judge, and it's certainly not the defense attorneys. The prosecutors drive the train. They decide to put 28 defendants in a RICO indictment. They are the ones that decide to create this gargantuan size indictment that the court system cannot digest easily. It's not bite size. It's not the kind of thing that, you know, a jury can come in and deal with in 3 or 4 or 5 days or even a week or two. You know, it's been going on for like 19 or 20 months already, and they don't even have all of the defendants on trial. So this thing is so big because she made it that way. And it's, you know, if it's high profile, it's in large part because of her press conference. She sought to make it high profile. But of course, one of the first things out of their mouths at that press conference was how Jeffrey Williams is of some notoriety. Well, he's a famous rapper. He's Young Thug. Okay. And, you know, YSL, you know, whether it's a criminal street gang or not, is not what we're here to talk about. You know, she has made this what it is. And now she, through her assistant prosecutors, you know, they filed the motion to gag the defense lawyers. Some people have asked me on social media and even on comments to some of these recent videos, why do I call this Fani Willis versus Young Thug? Well, that's why. Because if it wasn't, if it wasn't Fani Willis versus Young Thug, then what is it? She's the one that made it a RICO case. She's the one that came out with this press conference, and she's the one who's taking credit for all of it. And you got to know she's driving this train. She may not be in that courtroom like she was in some of the Trump hearings in that RICO case that we've also talked about here inside the law, but she is driving this train. It is very much Fani Willis versus Young Thug and Mr. Kendrick and all the other defendants. So without further ado, I want you to all give a big round of applause and welcome back inside the law to our friend Doug Weinstein. Doug, good afternoon. How are you, buddy?
Good afternoon, Philip. I'm doing great. Thank you for having me on.
Oh, listen,
always a pleasure.
Thanks for sharing some of your afternoon with us. I noticed in yesterday's live stream, I went back and watched it. I saw that you were actually in the live chat. So thanks for watching. And you saw that yesterday what we did, and we're going to pick up sort of almost where we left off, but we want to talk about, you know, your response to their gag order motion and also the motion for mistrial. But there's a lot of other motions that might not be yours that maybe you can bring us up to speed, at least on what's been filed, what's going on, what's coming up next. And also, I understand that the prosecutors have I think responded to your response, which we covered yesterday. Is that correct?
They have responded at midnight last night to the motion for mistrial that I filed. I believe that response also covered the motion for mistrial filed by Brian Steele and the motion for mistrial filed by Max Shart. They filed a separate document responding to Bruce Harvey's motion for mistrial. So they have two responses to the motions for mistrial.
Right. So
yeah, go ahead.
What I'm going to do is I'm going to try to share, since we're talking about your motion for a mistrial, I'm going to see if I can share that with the folks here watching live. And if I'm successful, I'm not very tech savvy, but here you go. I think this is it. DeMonte Kendrick's motion for mistrial. And we covered this, by the way, a few days ago at length. And if you want to go back, obviously, on the channel and find that video, I forget what day it was, but it's easy to, it was recent. We went in detail covering this motion for mistrial. But anyway, now that I've got it up on the screen, Doug, I didn't want to cut you off necessarily, and I apologize, but I did want to bring this up so we can have it in front of it to refer to. So go ahead, pick up where you left off.
Sure. All of the gist of this motion for mistrial is that we were forced into filing this motion for mistrial because of the actions of the prosecutor and to some extent the actions of Chief Judge Glanville, but really focusing on the prosecutor. And so we were goaded into this position.
All right, let me pause you. By the way, and sometimes people get mad at me. They say I cut people off, but what I'm trying to do is guide the conversation. You and I speak a little bit of a different language. We speak legalese, and we speak lawyer talk, and you and I can have a conversation and talk about things like goaded into a mistrial. And I don't know exactly what you're talking about, but for those of who are watching live or who may watch on replay, and those, of course, who are very active in the chat, thank you very much. They may not know what that means. So can you explain the significance of the words you just used when you said goaded into a mistrial?
Right. And those are very specific words, and it's a choice that I consciously make, because when I say goaded into a mistrial, what I am saying is the prosecution, their actions that they took, the ex parte meeting that happened with the judge, that secret meeting with the judge and with Mr. Copeland, the intent of that, when they did that, was to force us into asking for a mistrial. And the reason, and I'll be quiet, the reason they forced us into asking for a mistrial is they are losing this case and they would like a do-over. And I think anyone that watches can see that.
All right, let me ask you this for those who may not know the answer. Educate our audience, please, Doug. If a defendant asks for a mistrial and it is granted let's just say it's an ordinary mistrial, for lack of a better word, a garden variety mistrial, what would happen after that?
Yeah. In general, the law is that if a defendant asks for a mistrial and that mistrial is granted, then the state is free to retry that defendant. So they get another shot at it. And that makes some sense if you think about it. If it's the defendant requesting, and I don't know if I totally agree, but that's the law. If the defendant requests it and it's granted, then the state has another bite at the apple.
So the double jeopardy clause would not apply unless your mistrial is caused by what?
The double jeopardy clause that we all know, I think, would apply if the reason that the defendant has to request that mistrial is because they essentially were provoked by the state intentionally, with the intent, really, that the state is hoping the defendant asks for a mistrial.
Well, so here, and I just highlighted it should be on the screen here. It's that you wrote, now goaded by the state and the actions of Chief Judge Glanville, Kendrick has no option but to move this court for a mistrial with respect to the constitutional rights of Kendrick and not defeat the ends of public justice. Normally, we don't see the language. I've seen the language, goaded. That's, you need to put that in there, but you don't normally see the judge included in the reason for that. So what's going on here?
Yeah, there's also some case law that if it's the judge that has put you into this position, that the double jeopardy clause may also apply. So the language, which is a little stilted, I know, and doesn't really flow off the tongue, or even when you read it, it can be a little clunky. So I struggled with that. But what I'm doing here is I am essentially paralleling the language in various cases that support that if a mistrial is granted, double jeopardy should apply.
All right. So how, I think I know the answer, and those who have been following, and certainly my audience probably knows the answer, but I want to hear you, if you don't mind, articulate how you were goaded, Goaded, not goaded like the farm animal, how you were goaded into having to move for this mistrial.
That's a great question. So what happened is, when the state requested that ex parte meeting, I believe, and I think it's clear to people that see it, that the intent of that was to put us in this position of having to ask for a mistrial. Now, why are we in this position? Why would the ex parte meeting put us in this position? It puts us in this position because Mr. Kendrick, and through his lawyer, myself, we have a right to be present at all critical stages of this trial. And when you have got the key witness for possibly the entire case that the state is bringing, certainly for the murder of Donovan Thomas, when you have that person and he has refused to testify and he has been jailed for contempt, and now you are twisting his arm, you are hotboxing him, you are bullying him into changing his mind, really involuntarily. That's a critical stage by any measure of the law, and we should have been present. So Mr. Kendrick's constitutional rights were violated by us not being present. The actions, and I'll be brief, I promise, I'll try to wrap it up. The actions of the judge were improper in coercing Kendrick to testify. That's another constitutional violation. So in that sense, because look, any lawyer knows that that meeting was improper. I'm going to disagree with Judge Krause here. And she did what she had to do to give us the disqualification. So God bless her for that. But I think any lawyer knows that. So the prosecutors had to know that what they were doing was improper. They had to know that this would be our response. And this was the intended response of the state. And that is all that I argue in this motion. I have one additional thing you can ask me about later, but those are the two of the three reasons that we're requesting a mistrial.
Well, we definitely want to get to everything you've got to say. I think it's fascinating. Welcome, by the way, for those of you who might just be joining us. I see there's now 715 people in here live. Welcome to Inside the Law. We are discussing the real criminal justice system today in the context of the Fani Willis versus Young Thug racketeering case going on in the Fulton County Superior Court in Atlanta, Georgia. And joining me as my guest is Attorney Doug Weinstein, who represents one of the defendants in the case and who has been instrumental. And I don't want to minimize the hard work of any of the other lawyers because they've all been working really, really, really hard. But Doug is one of the ones who sort of spearheaded the effort, I would say, to get the prior trial judge, Judge Glanville, removed from the case. He even went so far as to file what we call a petition for a writ of mandamus in the Georgia Supreme Court. And although he didn't win, the Supreme Court did not grant the mandamus. When they wrote their order denying it, they included some very helpful language that served as some instructions to the judges in the Superior Court. That's the trial court of Fulton County. It gave them some instructions about what sort of needed to happen. And Judge Glanville, who is capable of reading, read that, I am sure. And I think that went a long way in causing him to, at that point, voluntarily, air quote, voluntarily recuse himself. So Doug is with us explaining where things are now and why. We're going to get to the gag order and stuff later. But right now he's explaining to us why he has had, along with the other defendants, by the way, he's had to file a motion for mistrial, and he's asking for a motion for mistrial with prejudice, meaning that if it's granted with prejudice, the state could not retry these individuals. Doug, so I'm looking at your motion for mistrial here, and of course, you made the point that your client, Mr. Kendrick's rights were violated at a critical stage of the proceedings. Now, explain what you mean by critical stage. I know I'm putting you on the spot. This is like law school or criminal procedure stuff, but just in layman's terms, what are we talking about when we use the phrase critical stage?
Yeah, there's some specific definitions of how you decide whether something is a critical stage of the proceeding, but really the best way to think about it, this isn't completely layman's terms, but if it's something that really is material to the trial, something that could affect, let's look at it this way, something that could affect the outcome of a trial.
Yeah.
So here you have, in this specific instance, as I said, Kenneth Copeland, the key state's witness for the Donovan Thomas murder. By the way, Kenneth Copeland, as he himself has said on the stand, is not a credible witness. He says that he lies all the time, etc. But anyway, he's who they are relying on in their murder case with regard to Donovan Thomas. He said he's not going to testify. He said he's going to jail. He says he's happy to sit in jail till this is all over. He is not testifying, and they coerce him into changing his mind. That definitely affects or could affect the outcome of this case. Now, look, I think if he testifies, we still perhaps win this, we still should win the murder case. My client did not murder Donovan Thomas. I don't think the state can present even probable cause that he did, let alone proof beyond a reasonable doubt. But anyway, any way you look at it, Kenneth Copeland changing his mind is a critical, important part of this trial, and we should have been there for that.
Well, since he changed his mind after he was leaned on, and I use the phrase very generously, I guess, leaned on by perhaps Judge Glanville and others, threatened with being jailed for an indeterminate amount of time until all of the remaining defendants' cases were complete. I want to, just in case you are new here and you have never met Kenneth Copeland, I want to show you just a moment of Kenneth Copeland so you'll know who we're talking about.
Text message. I don't recall any conversation with Detective Thorpe.
I'm saying you can slow it down, but I'm gonna keep asking you these questions. So, do you recall texting or telling Detective Thorpe that another guy called you and said that those people were just lying?
I don't recall.
All right. So that's, you can get the sense there. He, among other things, it's obvious he doesn't want to be there. He did show up. He took the fifth. He had a lawyer. They threw him in jail for taking the fifth because they say if you're granted immunity, you can be compelled to testify. But of course, the Fulton DA's office has no authority to grant him immunity from any potential federal charges. So honestly, if he were my client, I would have told him to still take the fifth. But anyway, that's a taste of who Kenneth Copeland is. And I just showed that for a little bit of context here. The motion for mistrial includes a couple of other grounds. The first one you allege was that it says you're placed in the impossible position by the state that basically the court is in the impossible position, I guess, of having to reset this case to at least the point of the afternoon of June 12th, when your client moved Judge Glanville to recuse himself, and he improperly failed to halt the proceedings. Since that date, the jury has heard days of testimony from that witness, Mr. Copeland, who we just saw, and that testimony can't be unheard. Explain to our audience, Doug, if you don't mind, briefly, what is that paragraph about?
Sure. This is actually pretty simple. The law in Georgia says that when you ask a judge to recuse himself, he's supposed to stop everything at that point and refer the motion out, if you've met certain standards, which we met. He's supposed to refer that out to another judge to make a decision, and stop everything. Everything stops. The judge didn't do that. So if it's later found that the judge is recused, should be recused, you have to reset everything that he did after the point where he failed to stop the proceedings. Everything
So he
after
didn't
that
do
is
that, right?
void. Yeah,
So
he didn't do
how
it.
do
He
you do
didn't
that?
stop. He didn't stop. So everything after that is void. It's a nullity. It should not exist. Any rulings he makes, any testimony given. Exactly. How do you reset that? I think it's not possible to ask the jury to unhear, to ignore, pretend like they didn't hear testimony from Kenneth Copeland the rest of that Wednesday, Thursday, Friday, and the following Monday. They also have notes on this, by the way. The jurors are very good about taking notes in this lengthy trial. Do you take their notes away? Is that even proper?
Are they allowed to take those notes home? Do you think they have
No,
them
no,
legally
no,
now?
no. They don't take the notes home.
Okay.
They leave all their notebooks there. So, yeah, I don't think just as a practicality that you can, and the law requires it. The law it's crystal clear. The law requires that everything after that afternoon of June the 12th is void, and you have to rewind. And it kind of makes sense. I think your viewers need to understand when recusal normally happens. It's not normally in the middle of trial, right? You have this lengthy pretrial period with procedures, with motions, everything being argued. That's when recusal issues normally come up. So it's easy to kind of stop things, or even to some degree reset things, right? Because maybe the judge made a few orders after that. This is a highly unusual case. I think there's someone that looked up this and found maybe 10 instances across the country. He's on your chat right now. But he found, I believe, 10 instances across the country where a judge has been recused in the midst of trial. It's very rare.
I apologize. I'm unable to I can't watch the chat, and I'm doing multiple things here on my screen. So I must have missed that, but that's very interesting to learn. I think that, like, normally, right, I'm gonna play devil's advocate. Let's say we have a trial, and let's say I'm the prosecutor, you're the defense lawyer, and I ask a question, and you stand up right away and object, and you say, "Objection, Your Honor, it's hearsay," or it's for whatever, any valid objection. And before the judge can respond, the witness blurts out the answer, right? And then the judge sustains your objection and says, the jury will disregard that answer. Well, how is this different from what, because that happens all the time in almost every trial. So how is this different?
I think the difference is that in that circumstance, which does happen all the time, first of all, I question whether the jury really ignores that. But putting that aside, that's a single statement, and you're instructing the jury immediately to ignore it. Our jury heard 4 days of testimony, or 3+ days of testimony. And it was over a month. It was 6 weeks ago, 7 weeks ago. And here's another question. How do they, in their mind, sort the testimony that they heard from Mr. Copeland on June 11th, or earlier in the day on June the 12th, or in the afternoon of June the 10th, from the testimony they heard the 13th, 14th, and 17th? You're asking the impossible of these jurors. And I made that point in this motion.
All right. Let's get back to your next ground. This is pretty short. Kendrick's due process for rights were violated when Judge Glanville wrongly coerced Copeland to testify. Explain.
It is clear in Georgia law, actually national law, that you as a judge are not permitted to coerce a witness to testify. You cannot coerce a witness. And that is exactly what Chief Judge Glanville did in conjunction with the DA's office when they said, you're not only going to sit here until the end of this trial, and as you said earlier, Philip, you're going to sit here until all these, there are 28 defendants. Now, some have pled out, but there's a lot of defendants left to try. You're going to sit here till every single one of them has been tried. And that was just too much, clearly, because he changed his mind after that.
Well, it occurs to me that when, look, we can agree, I think, that when you grant a witness immunity, they're not, taking the fifth doesn't mean anything if they have been granted immunity, because they can't, by definition, they can't possibly incriminate themselves if they can't be prosecuted for the words that they say from the witness stand. So I guess in that sense, and we get this question a lot, people ask me, can they force immunity on him if he doesn't ask for it? Well, the answer is yes, they can. They can immunize anybody they want to. They're the prosecutors. That's kind of it's in their prerogative, so to speak, as long as the judge signs off on it. But so in that sense, you can coerce somebody to testify. If I'm suing you, Doug, because we had a car wreck, I can compel you, I can force you through the subpoena power of the court to come to my lawyer's office and sit for a deposition, or come to the courthouse and testify under oath. In that sense, we can compel testimony. But the issue arises when they want to compel his testimony by, throwing him in jail until he testifies, when his grant of immunity is incomplete. It doesn't include protection from any potential federal charges. And as we all know, there's a lot of overlap, right?
I agree. And I want everyone to also picture this. You are Kenneth Copeland. You are in the judge's chambers. There are 4 deputies from the Fulton County Sheriff's Office there around you. There are 1 or 2 prosecutors there. The judge is there. There are 2 investigators from the Fulton County DA's office there. I don't have a photo from there, but presumably they're all around you. And here they are, pushing and pushing and pushing you to testify. And you do have your lawyer there. I will say you did have one person in his corner, I guess you could say. But that is terribly intimidating. Look, just testifying is intimidating. I've been deposed. It's very unpleasant. Just being deposed is intimidating. Imagine what this was like in the judge's chambers. Just picture it in your head.
Well, you're getting this information because there was a transcript that Judge Glanville did allow to be released, because he had a court reporter back there. But there's parts of it, I understand, that were off the record, and we don't have any clue unless you get these people to come into court and testify. That's the only way you're going to find out. I mean, and by the way, I just highlighted in your motion here the portion, and I know that my moderator has, I think, linked to this, so anybody can go look at it for themselves as well. So thank you for that. You point out that this ex parte, which is this illegal one-sided proceeding, was held in Glanville's chambers on that day. The attendees were Glanville, Assistant DA Love, Assistant DA Hilton, investigators from the Fulton County DA's office, deputies, which I guess are courthouse security type deputies, presumably wearing body camera, the witness Copeland, court staff, the attorney, Ms. Bumpus. You point out that no member of the defense counsel was present from any of the defense lawyers were there. And that despite Copeland's invocation of the Fifth Amendment, he was pressured. It says neither Glanville nor any member of the court staff nor the DA's office told any of the defense lawyers that any of this was even going on. And I just can't get my head wrapped around how any lawyer can think that that's okay. The prosecutor's very flimsy excuse was, well, this was, they don't have a right to be there when we're granting him immunity and all this, but that's not what they were doing. That's not what they were doing, Doug.
ADA Hilton she's an excellent attorney. She's a very good prosecutor. She is clearly very smart. She had to know that this would be our response, a motion for mistrial. She had to know that.
I mean,
I can't believe
anybody with a
otherwise.
brain should know that.
Well, and she's more than that. She's a very smart lawyer.
All right, so let me pause for a second, Doug. We've got we got some questions, if you don't mind answering them. And thank you, by the way, for the super chats. I'm not ignoring them as they come in. I'm trying to get to a place where we can stop and sort of acknowledge those. Kim, thank you very much. And that's what we try to do, is keep you informed. She wants to have the same defense, and like the Trump march and gag order, the plaintiffs only. Okay, so we are going to talk about the gag order. So thank you, by the way, for that super chat, and we're gonna come back to that. Your question will be answered when we get into the discussion on the gag order. Dr. Pat asked, can we disbar and dismiss without prejudice already? Well, I don't want to get into too much of a discussion about disbarment. I covered a little bit of that yesterday. There was Jonathan Melnick, the attorney, I guess former attorney for Mr. Copeland, had indicated he was going to do something like that. But we're not here to talk about bar complaints today, but dismissing without prejudice. Doug, I noticed there was I forget which defendant it was. Somebody filed a motion for a mistrial, but it did not include the language about being goaded into it. So presumably it's a motion for a mistrial without prejudice. Is that correct?
Yeah. And I think, to be clear, I don't believe I specifically asked for prejudice or a finding of double jeopardy. I take everything a stage at a time in my motions. So right now I'm just trying to get the judge to rule on the mistrial, and the reasoning being goading. If we get
I think when you put goading in there, that's why.
That's where I'm going next. Yeah, that's where I'm going. Obviously, that's where I'm going next.
Yeah,
I read Bruce Harvey's motion for mistrial, and I think that's the one you're referring to. Okay. Bruce Harvey represents Mr. Nichols, and he has, as I read the motion, again, I'm not comfortable really speaking about other attorneys' motions, but I believe that he did not request. He doesn't have goading. He just is. His motion talks about just the practicality of a judge parachuting into this case and having any hope of being able to conduct this trial. And I agree with Bruce on that.
Well,
and by the way, I would go ahead. I'm sorry.
Yeah, I of course don't know. Bruce is a fine, fantastic lawyer and a friend, and I have no idea what his strategy may or may not be, but it may very well be as simple as we're going to ask for the mistrial, and then we're going to ask the judge to make it with prejudice in step 2. It may be something just
perhaps.
as simple as that.
And it may be, and I don't disagree with his motion at all. It's a great motion. And then let me say this about his motion, and y'all haven't seen this yet because the state didn't do their filings until midnight last night, so they haven't been approved yet, accepted by the clerk's office. So I don't believe that those midnight filings are publicly available. I have copies because the DA's office, as instructed by the judge, as we all do, they served them on us. But I can tell you 2 responses. They have a basically 2-page response to my motion for a mistrial, and they have a lengthy response to Bruce's motion.
All right.
That's about 9 pages.
Let me hold that thought just for a second.
Sure.
And I got one more question for you. It's a question for you, Doug. How is a trial allowed to go on this long, and why are they always bringing crimes that happened decades ago?
That's great. A great question. I'll answer that in reverse order. As far as the crimes that have alleged, the crimes, I guess some of them did happen. Donovan Thomas was murdered and other issues. But as far as these old crimes, they're going back to like 2012 on these issues. We believe, and we filed motions, that there were statute of limitations issues in this RICO count. Judge Glanville ruled against us. I believe that was an error, and that will be an issue that will have to be taken up on appeal should we, God forbid, lose this case. So yeah, I don't believe they should have been going back that far. I think this case was improperly, the RICO charge at least was improperly brought. Why is the trial allowed to go on this long? That's a great question. This was a choice made by the prosecutor to oppose our motions to sever the case into manageable chunks. I can tell you in federal court, if there was a case like this, or when there's a case like this, they are broken up into manageable bite-sized chunks. Anyway, they opposed our motion to do that. The judge ruled against us on severing our clients or breaking this up into manageable bits. And then the Chief Judge Glanville, even though he's allowed to do under the law to put limits on the length of case that you're allowed to present, and I filed a motion for him to do such, he refused to put any kind of limit on the state. Not to talk too much, but there's a great opinion out of a judge in Kentucky, a federal judge, where he discusses this issue, and he basically says, look, if you leave lawyers to do whatever they want to do, they are going to dot every I, cross every T, leave no issue unturned, and present cases that will take forever. And it's in civil cases, you have limits because of the monies of the parties, but with a prosecutor who has no monetary limits, in that circumstance in particular, you can have them doing exactly what they're doing here, which is initially proposing 700 witnesses.
700. I can't even imagine. All right. So
Yeah,
the next
I think
question,
they're down to another 100. But yeah.
The next question is, why did the guy Fani Willis represent the so-called leader of YSL not get tried? Was there a period of time when she was in private practice that she represented someone?
Yes, I believe there was, and I'm trying to recall the alleged member of YSL she represented, but there was a member. There was someone that they alleged to be a member of YSL who she had previously represented that is not in this indictment. I don't really know why. I don't think any of these people should be in this indictment. Why that particular person wasn't named, I have no idea.
All right. Well, we can only answer what we know. Thank you for giving it a try. And Fletch points out, it's not a question, but it's an observation. It's worth mentioning. The original purpose of the Fifth Amendment was to protect against the British practice of having judges coercing testimony from a defendant, especially to inform on heretics. And yeah, the Fifth Amendment, just like most, thank you, by the way, Fletch, for the comment and for the super chat. And we'll get back to more of those hopefully later. The entire Bill of Rights, more or less, was put in place because of various abuses of people's liberty and freedom at the hands of the British. And so the Fifth Amendment, of course, being no exception. All right, before we
real quick, Philip.
Yeah.
I'm sorry, real quick. I just saw someone in your chat, Nia Roberts, mentioned that it was YSL Mondo and I'm going to say allegedly, just because I haven't looked all this up, but that Fani Willis allegedly represented previously. She represented Mondo, and Mondo was not in this indictment.
All right. Well, thanks for clarifying that. That's good information. That's something that's new to me. I had not been aware of that. All right. So before we broke for the question and answer, and by the way, we're gonna obviously continue to ask or answer questions. So keep asking them. And thank you very much for the super chats. For those of you who are just joining us, Doug Weinstein is one of the defense lawyers in the Fani Willis versus Young Thug trial, as I call it. And he is neck deep into motion practice here now that Judge Glanville has been removed involuntarily from the case. and we have a new judge, and a lot of the judge is trying to catch up on things, and the lawyers are trying to help her get caught up. And Doug has filed a motion now it's a motion for mistrial, and he wants the case terminated with prejudice. And I am told that Doug told us before we started the questions and answers that the state had responded. And so while if it's not been filed, I'm not going to post it and all that. But if you think it's fair to comment on the substance or the essence of what their response is to your motions, we'd love to hear it.
I could comment on the substance of it if there was any substance to it.
Oh.
I'm happy to. It's so short. It is less than 300 words. If you want to give me a minute, I can actually tell you. I don't want to share it because I don't have a file stamped copy accepted by the clerk's office. But and I can read part of it if you'd like.
Yeah, go ahead.
Sure, you'll be probably the first to hear it outside of us that are involved.
Right, we have breaking news here inside the law, folks. Here we go.
State's response in opposition to mistrial. Hi, ADA Love. Hi, ADA Hilton. How are you guys? Because I know y'all are watching me. The state of Georgia hereby responds in strong opposition. I guess that means they're really opposed. To each and every motion for mistrial made by the defendants currently on trial, and the state moves this honorable court to deny, bolded, all caps and underlined, each and every motion for mistrial currently under consideration by this honorable court. In support of this motion for denial, all caps, bolded, and underlined, of mistrial, the state shows this honorable court as follows. Okay, I'm approaching halfway through. To date, every defendant in this case has moved for a mistrial following the goading. This is a neat twist. To date, every defendant in this case has moved this honorable court for a mistrial following the goading by the defendants of the former judge's recusal. Further motions for mistrial were made by defendants prior to Chief Judge Glanville's recusal and were denied by the court. To the extent this honorable court considers or reconsiders any motion for mistrial made prior to the recusal of Chief Judge Glanville, the state moves this court to deny, bolded, all caps, underlined, those motions as well. Since Chief Judge Glanville's recusal, defendants Williams, Stillwell, Kendrick, and Nichols have each filed one or more motions for mistrial. 2 more paragraphs. Regarding defendants' assertions about the lead prosecutors, the state does not agree with defendants' characterization of events. It's good to know. And submits that this honorable court should not issue such an order as defendant Williams requests. Instead, the court should simply maintain what the court told the parties on July 19th, 2024, that it expects everyone to treat each other professionally in the course of this trial. Regarding defendants' demand for a mistrial, the state notes again that the hearing in chambers was proper, and they cite the same case they cited before to say that the ex parte meeting was proper. The defendants here are receiving and will continue to receive a fair trial. For all these reasons, the honorable court should deny defendants' motion for mistrial, respectfully submitted. So that is the sum and substance of their opposition to our lengthy motions for mistrial. So presumably they will have more to say when we have argument.
All right, that's great. Now look, I've got a secret. I'm going to tell you all a secret that it's going to be worth it. But as Daniel has asked here, there's 1,000 people in here. Please hit the like button so that we can get 1,000 likes here. And if we get them, somebody tell me when we get there, I will tell you all a secret about something that Doug just said to us. All right. So let me know if we get 1,000 likes, I'll tell you the secret. All right,
let me add one thing I should add.
Yeah.
I'm sorry. This is I don't know if this has any meaning or not, but this is the first pleading I have seen for a while that actually is signed by Fani Willis versus just being signed by ADA Love. Love is on the signature line, but Fani Willis is the one that signed this.
Oh, well, see, pleading. Well, that's like, you say you object to something. Well, your objection is overruled. No, judge, I strongly object. Well, if you strongly object, then that makes a difference. So I guess by having her name on it, it's supposed to give it some additional weight, maybe to let the new judge know that Fani Willis is watching her. Want to make sure she does the right thing. All right.
Yeah.
So when we get to 1,000 likes, and I can't see in my screen when we're there. So Texan or somebody, one of the mods, if you notice that, let me know, and I'll tell you a little secret about something Doug just said. All right. Now, that was their response to your motion for mistrial. Now, before we move on to the gag order issues, Doug, and I won't go through all of this. I've already done a whole live stream on your motion here, and it's very, very well written. And thank you for sharing it with me so that we can share it with our viewers here. All right, we got 525 likes. By the way, in addition to liking, please subscribe. I'm on my way, hopefully, to 50,000 subscribers. I'm almost at 46,000. So if you haven't subscribed, please go ahead and subscribe. But by hitting the like button, it helps other people who might be interested in this kind of subject matter to find the channel. Because here inside the law, we are about learning. We might have a little fun along the way, but we try to learn something and about the real criminal justice system and how it works. So hopefully, folks can find us. So thank you all who have subscribed, and I really appreciate the support. All right. So we're going to get into the gag order stuff, right? You had filed a very interesting objection to the state's gag order. And so if I can, let's see, I want to see if I can find that. But while I'm pulling it up, Doug, tell us about the gag order motion that was filed and what they're trying to do to you guys.
Yeah, it's an interesting motion in the sense that it's very short. There's no law, if I remember right, cited in their motion for a gag order. Forgive me, I don't have it in front of me, but if I recall, there's no law in there.
You're
no
right,
case
I
law.
remember.
And they don't include a proposed order, which is quite interesting because I'm sorry for using the term gag order. I really don't like that term, but it's just the easiest way to refer to it. But when gag orders are granted, they are very carefully, narrowly crafted in order to not offend First Amendment principles. So normally what I would expect to see in a motion for a gag order is a proposed order. Actually, almost any motion I expect to see a proposed order, but certainly a motion for gag order. There's no proposed order, and the request is incredibly broad, which is the defendants are not to speak about the case. So I don't know if you covered the gag order in the Trump trial in New York.
Yeah, a little bit.
But you can agree with it or disagree with it. But if you read it, the attempt is for it to be narrowly crafted to achieve the aims of the court without violating former President Trump's First Amendment rights. Nothing like that is attempted by the state in their motion for gag order against the defendants.
And I think it's probably fair. I'm not trying to put words in your mouth, but I'm before anybody misinterprets that, neither Doug nor we're not talking about the Trump gag order, and Doug is certainly not saying it was appropriate. Doug's point is simply that the judge, when he issued it, he, at least on its face, it appears he tried to make it somewhat narrow. Here, they're not asking for any narrowing. It's just a blanket, you can't talk. In other words, Doug can't come on inside the law like he is right now and doing what he's doing.
And I missed the beginning of your broadcast yesterday, so you may have gotten into this. This is an unusual time for a gag order to be entered, right? Normally, they go before you have a jury seated so that you do not prejudice potential jurors prior to their being seated in court, correct?
Yeah, normally you see it right at sometimes you see it in the investigative stage. Yesterday I think you were here when we were talking about the gag order in the Ryan Duke case, which is from the Tara Grinstead murder. And if I recall, that one was very early. It may have been post arrest, pre-indictment, but it was very early. And that's typically when we see them.
Right. And I don't always or even often agree with those, but I understand it prior to a jury being seated, to try to keep the pretrial publicity such that it doesn't affect jurors who are eventually seated. I get it. We have a jury here. They're seated. They're not allowed to consume any of this. They should not. They have been ordered not to watch this. They're reminded every day that they sat in court. At the end of the day, if you watch the trial, what did you see Chief Judge Glanville say? All right, now I'm going to go through my ad nauseum admonitions with you. And he would do it in a more lighthearted fashion, but it was clear. Don't consume any information about this case outside of what you hear in this courtroom. Do not investigate issues yourself. Do not go to scenes of these incidents. So nothing I say can prejudice the outcome of this case.
All right. So I don't know if you can see the part of your motion that I put on the screen or not, but I tried to make it as big as I could. You dropped an interesting footnote. Let's see, you basically said that, let me get back to it.
It's a little north of where you are right now.
Yeah, there it is.
Yeah.
The only improper prejudice to the jury has been brought through repeated eye rolling and facial expressions of ADA Love, who is sitting mere feet from the jurors. What's that about?
Yeah, it's an interesting, and this is a normal setup. It's not that unusual, but because we have so many jurors sitting on the case and the way that the prosecution table, right, is always right next to the jury box. And by the way, proximity, there's been studies on this, proximity breeds relations, like a relationship can develop there. They are very close. There are jurors 3 feet from the prosecution table, 4 feet, I mean, very close. You can't see them on TV, but they're right there. And I mention this because one of the reasons I mentioned this is, and it was brought up by Keith Adams in court. ADA Love will, and look, I have no poker face, maybe as well, but ADA Love will make she'll make exaggerated facial expressions, eye rolls, body movements. You can see them on YouTube. I'm waiting for someone to compile them into a single video, which I'd love to show to the judge. And some of it is caught on camera, not all of it, because obviously she's facing away from the camera. But if there's anyone prejudicing the jury, it's these nonverbal cues that she's giving. And I think they're wholly inappropriate. And Keith Adams has asked for them to stop. I would like them to stop as well. I try not to do that. I don't.
Well, so this was something that was brought up with Judge Glanville, right? And did he take any action?
I'm sure. I don't specifically recall, but when these issues are raised, he did the usual, hey, both sides, both of you guys need to act professional. You have ethical responsibilities to yourselves and to the court. I expect both. So he always both sides everything. And he may have said something to that effect, but I don't specifically recall. I don't believe it resulted in any change in her behavior.
All right. So at the very beginning of your opposition to this gag order, and there's some interesting super chats I've been keeping an eye on that I'm going to get to in just a minute, Doug. We're going to be able to talk about something that little bit unplanned, but it looks like somebody brought something interesting to my attention. So we're going to get to that here in just a minute. But in the very beginning, you refer at the beginning of this show, this live stream, I played a few minutes of this press conference from, I guess it was August of 2022. And you quote Fani Willis, and you say, I think if you decide to admit your crimes over a beat, I'm going to use it. I'm not targeting anyone. You do not get to commit crimes in my county. I guess she owns it. And then get to decide to brag on it, which you do that for a form of intimidation and to further the gain and not to be held responsible. So she wants to go on the courthouse steps and go way, way, way beyond merely announcing the fact of an indictment and then saying, I can't take any questions. We'll have everything to say we're going to say, and we'll do it in the courtroom. So instead of doing it the right way, she says, among other things, she says that. And I want to get your take. I mean, I think it's pretty self-explanatory. And you talk about it, free speech for me, but not for thee. And by the way, I thought it was brilliant. The Sir Winston Churchill quote, everyone is in favor of free speech until someone says something back, and then it's an outrage. So I love the use of historical quotes like that. But how is it that you knew to use the words from this press conference?
Let me just to back up a little bit. For whatever reason, I'm tremendously offended when people infringe on the free speech right of others.
Me too.
If the Nazis want to march in Toco Hills, that's their right. If the KKK wants to march down Cleveland Avenue, that's their right. I would support them doing that. I'm close, not a free speech absolutist, but I admire the First Amendment. I think it's what keeps our country democratic.
Yeah, for sure. 100%.
So and if you recall way back, I was one of the people that really led the charge regarding the use of lyrics. I am personally tremendously offended by their use of lyrics. And that's a whole different episode we could talk about sometime. But then here they go again. So how did I know to go back and look at this? It was just a matter of, well, here they are again. Here they are again, trying to keep the public from learning about this trial. I have two roles here in going public, right? I have a duty to my client to speak out in public, to defend him in the court of public opinion, for his career, for his character. It's my job to do that, not just in the courtroom. And second, on a personal basis, someone who spent over a decade as an adjunct professor, I enjoy teaching. I think that what you do in educating the public is critical. So anytime I can participate in that and have that opportunity, I'm going to do that.
Well, for what it's worth, I'm almost an absolutist as well when it comes to the First Amendment, and we can despise what people say, and at the same time acknowledge and I think celebrate and support their right to say it in a peaceful way. So what this gag order does, though, this is yesterday we talked about this in the context of that Duke case. This is a prior restraint. They're asking the judge to silence you, and you're not coming on here and saying anything that's not part of the public record, things that haven't been said in court already. And to the extent that you may say things that haven't been said in court, you have a right to say those things anyway. I mean, so they're asking for this prior restraint, and under Georgia law, as we learned yesterday here inside the law, I invite everybody to go look at yesterday's live stream. If you missed it, we learned that prior restraint, that means gag orders, are presumed to be unconstitutional, and only a very, very limited, scant few of them can survive constitutional scrutiny.
Yeah. And by the way, regarding Fani Willis's press conference, I personally, even professionally, I don't know that she violated any I don't know that she violated any ethical code by doing this. Maybe she skirted close to the edge, but I don't really have a big issue with that press conference. What I have an issue with is you thinking that you can speak to the press, and you're the state. You are the all-powerful state, but I cannot speak to the press. That's hypocritical.
All right. So there was an interesting, by the way, let's hit some of these. There's a question here. Can the public help to get these guys bonded in any way? They got to get a judge, I think, to grant a bond. And otherwise, then it's up to them to figure out how to post a bond. I've heard of people having, GoFundMe's and things like that to try to raise money, depending on what but there's nothing the public can do. There's nothing anybody can do unless or until a judge grants a bond. Doug, you see it any different?
No, I think that's correct. And I know, and I haven't followed this as closely as I should, but I know our Georgia legislature passed a law, I think in the past session, that attempts to bar organizations from collecting funds to bond people out. That may have been stayed by a court. But anyway, I'm not sure of that situation. But yeah, we need the judge to order bond so that we can pay it. And I think our clients, certainly, again, as I always say, I'm only speaking for myself, but you've seen the bond motions filed. I believe Mr. Kendrick deserves a bond. I think he meets under the Georgia factors called the Aiello factors. I think he should be given a bond.
All right.
And thank you for attempting to support him getting bonded out. We do appreciate that.
All right. So here's, and by the way, if you are on X or you're on, X, Twitter, whatever, and you're not following Thugger Daily, you really need to, because that's one of the great places to go to get up to the minute, sometimes breaking information. Someone, thank you, by the way, for the super chat. Someone, True Story, asked me to look over here and check this out. And so it looks like, Doug, if you haven't seen it, maybe we can just look at it together. I see here, it says in a conclusion, for the reasons stated above, it would be an egregious abuse of the honorable court's discretion to disqualify CDDA Love and DDA Hilton based solely on the de minimis assertions advanced in defendant's motion, especially when there is no evidence of any ground authorizing either prosecutor's disqualification. This court should not abuse its discretion in disqualifying the prosecutors, especially where the June 10th, 2024 hearing about which defendants incessantly complain was in bold words, underlined proper, and where there are available to defendants other sources of information about which he claims to need to examine Love and Hilton at trial. Defendants' efforts to forestall the conclusion of the longest trial in Georgia's history by seeking to disqualify the lead prosecutor should be immediately stopped. This honorable court should deny the defendant's motions to disqualify the lead prosecutors in this case on the pleadings alone, I guess without a hearing, signed by Fani Willis, District Attorney. All right. So, but Doug, before I get you to comment, that looks like a response to Brian Steele's motion, maybe. But she says that this hearing, the ex parte, was proper, and I cannot disagree with her more. And by the way, Fani Willis ought to know something about grounds authorizing a prosecutor's disqualification, because that's what we're having a big fight about in terms of the Trump RICO case. And it's on appeal at the the Court of Appeals, and we'll have hearings on that in December. But when prosecutors engage in either misconduct or any kind of conduct that causes them to be a witness in the case, you can't be a witness and the prosecutor. That is black letter law. So if you're a witness, by definition, you've got a conflict of interest, and you can't handle the case as an attorney, prosecutor or otherwise, if you have a conflict of interest. So that's Fani Willis, and it looks like he says she preemptively argues that the defense calling Judge Glanville as a witness when the trial starts back. She says Williams asserts that he wants to call as a witness the chief judge who until recently presided over the trial. The state submits the chief judge is not a necessary witness for the same reason the lead prosecutors. I guess she's representing Glanville now. Moreover, at no point did the chief judge comment on the evidence before this jury. It appears the defendant's primary purpose in calling the chief judge would be to ask him to do just that. Although the defendant has not requested permission to do that, the state submits the court should deny it when and if it is made. And there's a link to the full motion. And there you have it. Breaking news. Doug, your thoughts?
I'm not going to comment too much on this because it's Brian's motion.
Yeah.
But I will say, simply put, well, first of all, let me make a comment. This same DA's office tried to disqualify Brian Steele before this at the beginning of this case.
Let me pause you. What was the basis?
Why
were they saying that?
I cannot recall. But I'll have to look that up later. But they tried to disqualify him. The issue is very simple. Miss Love and Miss Hilton and Chief Judge Glanville are witnesses with respect to what happened in the coercion of Kenneth Copeland. As you said, it's black letter law that you cannot be a party to a lawsuit and a witness in the lawsuit. It's not appropriate to have the jury judging the credibility of the prosecutor on the stand. So, having not read Brian's motion, having not read the state's response, just from my perspective, it's a very simple call. They are witnesses. We're going to need to call them. And let me tell you what else is going to happen. Okay? Not to forecast, but again, Miss Hilton is very smart. During cross-examination of Kenneth Copeland, Miss Hilton's name is going to come up. Miss Love's name is going to come up. Chief Judge Glanville's name is going to come up. There are a lot of issues here. That small portion that you read me of their response seems to be really well written. I'm looking forward to reading their entire response and seeing
I'm going to
what they have to say.
And I fully understand and appreciate you not being in a position or wanting to comment publicly just yet, but I suffer from no such issue. So I'm going to talk just a minute about this is where this is apparently it says Fani Willis's name on it. So apparently Willis says the hearing in chambers, this is the ex parte that you guys incessantly complain about, Doug. The hearing in chambers was about an ongoing contempt proceedings against a witness who, upon motion of the state, had been compelled to testify. The hearing was proper. She cites a case from 2000, King versus State, ruling that where King had complained that the trial court acted improperly by conducting a brief hearing outside his presence concerning the state's request for an order to compel the witness to testify, that was, they ruled that was proper. But first off, I'm familiar. I've read that King case, and I've seen this same argument made by these prosecutors before. They're saying that this is proper because in the King case, there was something that was very brief that happened that was limited to conferring use and derivative use immunity on the witness. But that's not what happened in this case. This was not he had already been granted immunity. This was not a brief discussion about the nature and the extent of that immunity. This was a judge bringing out the Georgia law book and reading him the Georgia code and threatening him to keep him in jail essentially indefinitely. And there was other things that went on. So just on the facts alone, I can tell you that their cite to this King business is garbage and it's nonsense.
But it's in their defense. We've all been in this situation. You have a difficult argument to make. You do the best that you can, right? You pull up. I mean, clearly they can't find case law to support their position that this was proper.
Well,
So
this
they found
case
the
law doesn't
closest.
support it. No, I mean,
No, I don't think it does either. At least they're honest about it to some degree in the parenthetical. They don't seem to mischaracterize the facts too much. They
you and I
cherry
can
pick a little bit.
agree to disagree on that.
Okay.
I think this is a little bit disingenuous, but go ahead.
Yeah, we've all been in difficult positions before, so I feel for them a little bit there. Of course, they put themselves in that position.
I would nominate Doug for the next Secretary of State because his diplomacy skills are better than any I've ever heard.
I think they would disagree with you. The state would disagree with you.
So it says here. So what they're basically saying, all right. So the king was where I guess there was some issue where the defendant wanted to object to the order compelling his testimony under immunity. That's not what y'all were doing. Y'all weren't objecting to the grant of immunity. At this point, you're objecting to the ex parte full blown hearing, and I guess everybody and their brother, except any of the defendants and their lawyers, was there. I mean,
and I think, if you read Judge Krause's opinion, in which she basically found the ex parte was not improper, she did say it could have been done in open court, and I believe she says something to the effect of, and maybe should have been done.
That's exactly what she said. Yes.
And how do you have faith in the judicial proceeding or the judicial system when things are being done in secret?
So the defendant, Fani Willis, says the defendant had no standing to contest the grant of use immunity to a witness. The in-chambers hearing was proper, but that's not what you're doing. You're not contesting the grant of use immunity.
No. It's like when Chief Judge Glanville came out, June the 12th, I presented him as required, my motion for recusal to him. And he left the bench and came back a few minutes later. And he said that I was complaining about an order or a ruling of the court, completely mischaracterizing my motion and the basis therefore. And that's what appears to be happening here. There's no one is complaining about the grant of use immunity.
What she says, Fani Willis says it says under the law, the King and Allen cases, the in-chambers ex parte was proper. She's not even calling it ex parte. She's just calling it an in-chambers hearing. The defendant had no standing to contest the hearing or to participate in it. And this is just one of those things that blows my mind. I can't wrap my head around anyone thinking that this ex parte was in any way proper. It was not a hearing on whether to grant the immunity. That had already been done.
I don't think you can find an attorney outside the Fulton County DA's office that thinks that was proper. No. And I suspect, if put under a truth serum, I don't know if you could find any DA, any lawyer within the Fulton County DA's office that thinks that was proper. Maybe. If they do, they're wrong. That was improper. It was unjust. It was a constitutional violation.
Well, this is more than we're going to be able to get into today, but it's going to be it's interesting reading, and unless I'm mistaken, I'm sure our moderators have perhaps already linked to it. Of course, you can go to Thugger Daily, where he has the link on his feed. Let's just pull that up. So there you go. Find Thugger Daily, and you can download it right there. He's very good about. And I'm not sure it's a he, by the way. It's an anonymous account, but
I've heard him. I've heard him on Twitter on Spaces, Twitter Spaces. So okay. I believe that person is a he.
All right. Well.
But he is the source for live tweeting of the trial.
Yeah, very, 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 very good job, and we appreciate. Look, and there's no one person that can do all this. There's so much information flying around that. Thank goodness we have people like that who are willing to take the time to do it, and people like you, Doug, who are willing to take an hour and a half on a weekend and come here inside the law and help us break it all down. Can somebody tell me how many likes we have right now? Put it in the chat, because I really want to tell you guys what my secret is that you'll get some benefit from. Thank you all, by the way. We've had some great questions. All right, we're at 751. Let's get a few more while I look for a couple of questions to answer.
Can I interject to say something while you're
Please.
looking for those questions? I think it's interesting how everyone covering this case seems to have a little different role. You do by far the best job of going through, taking these motions, taking these filings, going through them and explaining them in terms that I think any layperson can understand. And you provide a very valuable role in educating the public on not just this case, but understanding the law. Because it certainly is not like in the movies, is it?
Oh, I need to mark this timestamp at about 1 minute, about an hour, 25 and a half, because Doug, thank you. That's one of the nicest things anyone could say, because quite frankly, you know, to me, if I were going to a continuing education and there's a lawyer up there just, you know, reading a pleading to me, I'm going to go to sleep. I'm probably going to leave. But I do understand that I may be different than my audience who, you know, these by and large, not all, but by and large, it's laypersons who may have little to no formal training in the law. And so they do have a sincere interest in it. And that's what we try to do here. I had somebody asking me, why am I not talking about all the other stuff that's going on in the news? And while it's certainly newsworthy, we got a lot going on in America right now. This is not supposed to be a political channel, really. I mean, we've talked about the Trump case, but that's because it's in the news as a legal case. Okay. So we're not here to talk about assassination attempts, although there's plenty to say. And my friend Eric Hunley does a great job over on his channel. Check out Eric and Viva Fry. Those guys are doing a great job with all that stuff, but it's really not sort of what I'm here trying to accomplish. And I'm probably going to go on their shows to talk about it because I do have some things to say. But, you know, this channel is about trying to learn things about the actual justice system. So thank you very much for those wonderful, kind words. Here's a question. If ex parte is prior, then why did the Georgia Supreme Court just list that as one of the reasons that they removed Christina Peterson from the bench? Ex parte is improper under almost all circumstances. There are certain limited times when it can be appropriate. If a police or a prosecutor, if they're swearing out an arrest warrant, that's by definition an ex parte hearing. If it's a temporary protective order, it's an emergency kind of thing. That's if you want to call the judge's office and say, hey, judge, can you schedule this motion for your next calendar? Can we get a hearing date? Those are the kind of routine things having to do with scheduling, and they're not substantive. So outside those limited reasons, if a judge breaks the rules against ex parte, they can be removed from the bench, and it's happened before. And that's why I've said before, and I'll say it today, and I don't expect Doug to weigh in on this, but I think Judge Glanville needs an attorney. He needs to look at very seriously and rethink what he did here.
I won't speak to that, but let me say this about the Peterson opinion of the Supreme Court. If I'm recalling, so much has happened, not in the world, of course, but also in this case in the last 6 weeks. If I recall, that Peterson opinion from the Supreme Court came out 1 or 2 days prior to the Supreme Court issuing its opinion on the petition that I made to them for the writ of mandamus. And I sensed in that order on Peterson that they were also sending a message to Chief Judge Glanville. So when I filed, and you may have covered this, but when I filed the petition in Fulton the next day on a Friday, I cite that Peterson opinion in my petition to Fulton County Superior Court.
Yeah, and you did, and I think that it was. Some people say it was just coincidental timing. I don't think so. That Peterson order had been holding for a while, and I think they felt this was as good a time as any to remind judges that ex partes are improper.
Yeah.
So one of the questions was, and apparently I lost it, but it had to do with the fact. Okay, so in this ex parte, there was apparently some of this was not part of the transcript that you guys got. So I think that if it were me, if I were prosecuting, or pursuing, I should say, your motion to for a mistrial, I might want to have the court reporter testify under oath to make a record. What happened when you were told to go off the record.
I don't know. I may have this wrong, but it is my understanding that I don't think the court reporter was present for the off the record portions of the conversation. I don't even think Chief Judge Glanville was present for the off the record conversations. I think that was limited to the state, Mr. Copeland, his attorney, the deputies, maybe investigators. I'm not sure who, but I don't believe Chief Judge Glanville or the court reporter were there at the time of the off the record
But if that's
portions
the
of the
case,
meeting.
I mean, I think you got to find out for sure if that's the case, and you may be sure. But if Glanville wasn't there, then that portion of it at least is not an ex parte. That's a meeting with.
Yeah, and here you're seeing the problem with conducting this secretly in a back room somewhere, right? Is that there's still facts about that meeting that we don't know. If you would have if the judge would have just told the state, no, I'm not going to do this ex parte, that would be improper. We're going to do exactly what I said last Friday. We're going to come in here. It's 8:30. We're going to talk in open court. Everybody's going to see what's happening. But he didn't do that. And clearly, as I said, I think every attorney in the U.S. thinks that was improper.
Certainly everyone. I've had judges that I've talked to. I've had prosecutors talk to me about this, because judges and prosecutors, by the way, they watch this channel. A lot of them do, because they tell me, and they'll tell me in private conversations that they just can't believe that this even happened. So it's not just me and you. We may very well be wrong. I don't think we are, but even if we are wrong, we are not alone. There's 99% of the state bar of Georgia apparently would be wrong as well.
Yeah, and let me say, I need to say this as well, because it's important to me. I like Chief Judge Glanville. I think in general he does a good job. I think he has a great reputation, and he has it for a reason. He just made a mistake. It was a big mistake, but it was a mistake, and I don't think that should color his reputation, all that he's done proper over the last 30 years. And that's not spin or PR or being diplomatic. That's just how I feel.
Well, Laura points out here that, first off, she thinks you're right. So
good for you.
Obviously very smart. The
I
court
love
reporter
you,
was not there, but she says, I don't know about Glanville. Judge Glanville's anger and insistence in knowing how Steele found out about it made it look much worse. And Laura, I think you're right. I think that certainly was a very bad look for him. You could almost see the veins bulging out in his forehead when he's just visibly angry. When look, we can do a whole nother show about the contempt against Brian Steele, but the fact that he clearly was unable to, or uneducated or unaware of the difference between civil contempt and criminal contempt until Ashley Merchant came and educated him. That right there showed me that he was acting out of anger and not acting out of, I guess, proper judicial temperament, if you will. That's my opinion. But the way that he came across was just awful. And it made it look like he was biased. It made it look like he was antagonistic to the defense lawyer personally. That's just my opinion, but it certainly didn't help anything. You're welcome to not comment on that if you don't have anything to add. Of course, you can if you want to, but that's just my thoughts on that viewer's comment.
I think I'm not interested in beating up on Chief Judge Glanville. I have too much respect for him to pile on at the present time.
Well, you said all you needed to say. You said in court, and you were very respectful.
I hope
And
so.
honestly, I think you handled it better than maybe I would have. I might have been a little bit more hot under the collar than you were. But Brian too, by the way, he just sat there and, okay, I'm going to go to jail. And by the way, if I'm going to be in jail, can you ask the deputy to put me in with my client so we can prepare for trial? I
Yeah.
thought that was brilliant.
It's a very difficult thing to go up to a judge face to face, and this is what the rule requires, and say, Judge, you need to recuse yourself. That is not an easy thing to do, but I had no choice.
Of course not. You were being an advocate for your client. Doug, before we let you go, tell me what we've obviously got a lot of motions going around. I've got to fully digest Thugger Daly's X feed here in a little while to figure out myself. As far as you know, what's next for this case? When are you back in court, and when is she going to tell you if she's having hearings, and what do you know?
Great question. We've heard from the court. We will not be in on Monday, but starting Tuesday morning at 8:45 sharp, and I believe it will be 8:45 sharp, she will take the bench, and we will proceed. She will proceed to hear arguments on these motions all day Tuesday, all day Wednesday, all day Thursday, and all day Friday, meaning 8:45 until at least 6. I'm not familiar enough with this judge to know if she'll go later than that. And she has not told us the order that we are arguing these motions. I personally think that Brian's disqualification motion needs to be heard kind of right off the bat, because that's critical if they need to be disqualified.
Yeah.
So we'll see. I'll be prepared to argue our motions anytime the judge asks.
Well, I want to follow up on that, but since you mentioned it, this is also something courtesy of Thugger Daily. I found this. He posted this a while back. The new judge here, she says court's going to be in promptly at 8:45, no matter what. If all the defendants have any of their lawyers present, she's ready to go. No more eating in court unless the day goes longer than expected and they have to work through lunch or dinner. No more extensive wardrobes for the defendants, asking to minimize disruptions in court. Defendants cannot use headphones during the trial. No gaps between witnesses. The state needs their next witness available immediately. So it sounds to me like she's literally laying down the law, no pun intended.
And I applaud her for this, and we will absolutely follow these, and God bless her for these rules. I will say I don't recall the state having gaps in their witnesses in the past, but this is probably just a measure she's taken to let people know what she expects.
Well, and for the record, most judges expect that. This is kind of, most of these are standard kind of rules. I'm personally not a fan of starting before 9 o'clock, but that's just me. Maybe one day, if I ever wear a black robe, I can set my own courtroom hours. But until then, she gets to set hers as she sees fit. But all right, so we've got hearings all week. Do you foresee the jury coming back maybe the week after that, or best guess?
That's still kind of up in the air. If we get through all the motions and she doesn't rule for a mistrial, then perhaps they could be back the next week. I think I have every indication that Judge Whitaker is very efficient. Presumably, I don't know what she's going to do, but I think we can probably get through all the motions this coming week. But we'll see. Because actually, we may need witnesses for some of these motions.
I was going to ask you, do you think there's going to be any defense witness? Obviously, I think, Brian has said that he intends to call these prosecutors as witnesses. I guess he's going to have to put a subpoena in their hand, perhaps the same with Judge Glanville. Then you're going to have issues about the subpoena and all this. So other than those issues, do you think that the defense will be calling any witnesses, or is this mostly going to be legal argument?
Just watch and see I'll leave it at that.
Fair enough. All right.
There you go.
And presumably maybe the state may have some motions, but I think you're right. I think hearing the disqualification against the prosecutors, that's got to probably be first out of the gate. All right. So I think somebody says we're at 850 likes. Doug, I'm going to tell you I'll tell everybody, I'll go ahead and tell you my secret a little bit early. I still hope everybody will hit that like button, because with 1,000 people in here, I'd like to see at least 1,000 likes. But hopefully we'll get to that point real soon. And thank you for those who have already hit the like button. All right. So my secret, although someone referred to it as a dirty secret, I don't think it's all that dirty. When we finish this live stream and this video goes into post-processing, there will eventually be closed captions and there will be a transcript. In fact, I think that you'll be able to click on at the bottom of like the comments section. I think it provides even a link to a transcript. So when Doug read the state's response to his motion, you'll be able to at least get a transcript of Doug's words if you can't get the actual motion. But probably Thugger Daily will have it posted on his X feed soon enough anyway. But whether you want to use the transcript of this, and by the way, thank you all who have been here in the chat. I go back and I read the comments from the live chat a little bit later on when they're available, because I'm not able to catch all of them. Super chats are starred, and so they're brought to my attention. It's easy for me to see those, but the otherwise the chat is not something that I can always see as I'm doing these live streams. So I do like to go and see what you guys are talking about. And I like to try to answer questions. So put questions as well in the comments to the video. Even if you're watching live, go back later and make a comment, post a comment under the video. And for those watching on replay, ask me your questions and I'll do my best to try to answer them. Doug, what else do you got to add before you spend the rest of your Saturday doing Saturday stuff?
Yeah, nothing other than thank you very much for having me on, and thank you for continuing to educate the public about the law and about this trial.
Well, look, I try to do my best. I'm just one person. I don't claim to have all the answers. I might know a little bit more than some people about the law. And if people disagree with me, this is a free speech zone. I want to hear about it. Tell me if you disagree with what I say. I get a lot of stuff wrong all the time, but hopefully we do. When I have the help of good lawyers like you and guests to come in, hopefully maybe working together, we can at least educate people just a little bit. So thank you very much, my friend.
Thank you. That's very kind. All right. Well, stay in touch.
Take care. All right. So we'll send Doug back to do the rest. Look, I think it was a great discussion. I am personally, I feel much more informed about this, what's happened in this case so far. I feel like I'm more informed about what's going on. We've done live streams about Doug's pleadings, but now having him here to give sort of the, his take on it all, I do feel personally more informed, and I hope you are, because that's what we do here inside the law. We try to learn something and we use these court cases. Eventually there's going to be something going on besides the YSL trial. But right now in America, most of the news cycle is politics and lots of weird and unusual things happening. And of course the Olympics and all this, but there will, we're going to cover other stuff than YSL, but YSL is something that we've been actively following. And I think we really have to keep up with it. And so I'm going to continue to do these live streams as often as it makes sense to do it, and as long as I'm able to do it. And so I want to say thank you to all of you who are watching today live and on the replay. That obviously helps me a lot. And thank you for the super chats. And if you like this content and you're inclined to support the channel, there are links provided in the show description for you to do that. I figured for about every hour that I put in here on camera doing a live stream, there's at least 2 or 3 hours of work either before or after that needs to be done to put out the finished product, as it were. So your support is greatly appreciated. And so I thank you for anyone who has contributed. And for those of you who might in the future, thank you in advance. Look, there's one thing that I want to make sure that you always remember. If you don't remember anything else about Inside the Law, or if you don't remember anything else about the YSL trial, please don't be this guy.
Man, can I get a water or something? I'm so high right now, y'all. I'm about to go to sleep on y'all ass. I ain't gonna tell you no lie.
Yes, you may. We're gonna take a break. Hang in there.
Whatever you do, don't be that guy. And look, enjoy the rest of your day, and I'll catch you back here next time Inside the Law.